Good morning. Happy Monday. So, news that I'm sure 99.9% of you don't want to hear is Randy's getting paid. Randall Scott Newman, the copyright attorney that everybody loves to hate, he got 2 settlements last week. Executive Lens versus Reed and Liberty Troll versus Reed. If I am remembering correctly, I haven't looked at them since last week. So, if I get the name wrong, you're smarter than a first-year family law attorney. A settlement means that the parties decided that it was in their best interest to pay a little bit to make the case go away, eliminate the cost of attorney's fees, eliminate the question of what will happen at trial, what the outcome will be, what the award will be. There is a lot of power. I mean, there is a reason why most cases settle, and the reason why most cases settle is because having a known result is better than paying a lot of money for an unknown result. It's much better. So that's news. I mean, good news for Randy, bad news for all of Randy's haters. I get it. I still don't understand why people think I'm on in the frauder DMA versus frauder troll. I don't know why people think I'm on one person's side or the other. And my assumption that DMA is going to get money out of this, that he has a viable cause of action, that there will be a payout on if this goes to trial, is based on the fact that an attorney, a competent attorney, Randy he's been competent, whatever you think of him, no matter how terrible of a human being he is, he's a competent attorney. You don't have to be a good person to be a good attorney. Not going as far as to say he's a good attorney, but he's definitely competent. I mean, the results are speaking for themselves. He's a competent attorney. You can't say he's not. I mean, you can't in good faith say he's not. The pleadings, the results, he's a competent attorney. Not every attorney wins all cases. Even great attorneys sometimes lose cases. A lot of it's based on the facts and the law. If the facts aren't on your side and or the law isn't on your side, then what are you going to do? But a competent attorney looked at DMA's case and said, we have a valid cause of action. And yes, I know one of his causes of action was dismissed. The rationale for that is pretty simple. They applied for a copyright on one of the videos. By the time the motion to dismiss would have been heard, the copyright had not been granted. Apparently it takes some time. And because the copyright hadn't been granted, because it hadn't made its way through the process yet, he let it go. Does that mean he was bad to bring it? No. I mean, how was he supposed to know how long it would take for the copyright to go through? So again, I haven't seen incompetence from him. I've only seen competence. Some of his pleadings are kind of meh, but they're enough. He's competent. He hits the points he needs to hit. So based on that, based on him being a competent attorney, I assume that when he looked at DMA's case, he said, you know what? There's something here. There's enough here that I'm willing to take it on contingency. Because this I have been telling you guys forever regarding the auditors. If you have a good case, you should be able to find an attorney to take it on contingency. If you don't have a good case, the attorney will tell you he'll take it on an hourly rate. That is every civil case ever. Every civil case ever. If your attorney is saying, I need to get paid hourly, he's telling you that he thinks there's going to either be a problem in getting the judgment or a problem in collecting the judgment. But in this case, a competent attorney, the record shows he's competent, whatever you think of him, said, I think there is enough here that I am willing to do this on contingency. And that is an excellent indicator of the quality of the case. Generally speaking, hashtag not all. Your mileage may vary. Attorneys make mistakes. But he's been a competent attorney. And so, hedging my bets, I do think that DMA has a valid cause of action and that he is likely to get some kind of result. Even if it goes to Canada's just going to use federal law. So I strongly suspect that DMA is going to walk away with money. I strongly suspect if and when they get into that settlement conference, the settlement conference judge is going to say, you know, I've looked at everything, and you probably, you know, I've read the briefs. You're probably going to end up paying him some money. So the question is, how much are you willing to pay, and how much is he willing to accept? I am not making any judgments based on the pleadings, based on copyright law. I am basing my judgment on the fact that a competent attorney took the case on contingency. I'm not qualified really to talk about copyright law to know who has the better case. I am competent enough to know how attorneys function. You can disagree. And if you're a copyright attorney and you disagree and think that DMA has no case, great. Maybe I'm wrong. Maybe Randy was wrong. Maybe. But if I was going to bet on it today, I would bet the end result is that Fraud or Troll is going to pay DMA some money. And right now, you know, as competent as Lou is, and Lou seems to be very competent, his strategy is procedural delay, running up costs, making things harder, throwing a wrench in the works to try to gum things up. If that's your strategy, that tells me that Lou thinks that Fraud or Troll is going to end up paying DMA some money if and when this goes to trial. Or else, let's go. I've got my facts and evidence. You've got your facts and evidence. Let's go take it to the jury. See what the jury does. But he's not doing that. So again, I'm not basing my understanding on copyright law. I'm basing my understanding on the actions of the attorneys, based on my understanding of how attorneys act in civil litigation. And you're only a first-year family law attorney, John. Yeah, I know. I'm just a first-year family law attorney. But I've been a first-year family law attorney, and I've done enough civil cases enough to know kind of where things are. So, in other news, probably decreasing in interest for people is Earl Warden's petition to have the Texas Court of Criminal Appeals, which is the highest court in Texas for criminal appeals. They have a Supreme Court that only does civil, and then they have the Texas Court of Criminal Appeals that is the functional equivalent. It's on the same level as their Supreme Court that deals with the criminal stuff. So they've essentially bifurcated their Supreme Court into two courts. The Texas Court of Criminal Appeals declined to hear the petition for writ of certiorari on Earl's appeal. What does that mean? Does it mean Earl's done? No, it doesn't mean Earl's done. He has now exhausted his state court remedies. His next step, unless I'm dumb and wrong, assuming he still has a war chest, assuming he could still afford it, is to file a writ of habeas corpus into the federal district court and start running it up that chain. Again, his odds decrease as you go along, but he still has potentials. He still has a theoretical way to get a new trial, in theory. So, good luck to you, Earl. Good luck to DMA. Good luck to Fraud or Troll. I still don't have a dog in that fight. Someone's like, could one assume, based on your statements, that you're in favor of DMA? No. I'll be honest with you. As far as I know, I've never watched a DMA video. As far as I know, I might have caught a few minutes of a live stream where him and Randy were talking. I remember someone bringing it to my attention, but I don't watch DMA stuff. Why would I be on his side? I don't like most auditors, what have you. I don't like most of them. There are a few auditors that I think are good auditors who make good points, who aren't complete assholes, who tend to win and get settlements. I like those. But honestly, I don't personally think that auditing is as big of a deal. It's gone way down in my totem pole of issues facing the U.S. that should be addressed. I honestly don't think you should be able to film in a Social Security office. I just don't think you should. I don't think that you should be able to film without permission of the court in a courtroom 90% of the time. I just don't think that behooves anybody. You can watch, there's a lot of courts who stream their videos. You can watch what goes on in there. You could disagree with the judge, you could agree with them. But I mean, generally speaking, courts are open to the public. There are a few instances like juvenile court, things like that, where it's not. But generally speaking, courts are open to the public. You can go in and watch. You can hold them accountable by watching in person, or if they're live streaming it. It's just not a huge, to me, it's not a huge issue. 90% of it isn't a huge issue. And the transparency I want to see from the government is not what you can film from a lobby, but it's the mountains of classified documents that shouldn't be classified. Like the whole JFK file should be released. The whole 9/11 file should be released. Whether you think these things are giant conspiracies or not, like, light of day. Let the people see. Let the people know. Give them all the evidence. Maybe all the conspiracies will be quashed. Maybe the conspiracy theorists are right. I don't know. I don't care. Final note is I saw a clip from, what's that annoying guy's name? Ben Shapiro. I got him on my algorithm a long time ago. I was watching his debates and I thought, oh, he's a really good debater. He's annoying. He's a fast talker, but he's a good debater. And this was back when I was younger and dumber. People like to think that mistakes are something that you should be ashamed of. And generally speaking, as long as you learn from them, I think mistakes are a good thing. That's how people learn. People learn by making mistakes and getting corrected. The other day, I said that James Freeman had released the settlement documents. Well, I mea culpa. If you go to the description of that video, I mea culpa because it was pointed out to me that someone on Blue Sky posted that they had FOIA'd them, Freedom of Information Act, and they're the ones who got him because the settlement was over $30,000, and so therefore there's a law in Texas that means that municipalities can't keep those secret, so they had to release it on a FOIA. So it wasn't James Freeman. So I was wrong. You learn from your mistakes. You admit your mistake, you learn from it, you move on. In my comment section, there was somebody asked me, does Medicare or Medicaid, do they ever join in a lawsuit? No, they don't. They don't have a cause of action against the defendant in like a personal injury case. They don't have a cause of action. They're basically just like an insurer. The insurer can't sue on your behalf. You can file suit. And if you look at if you get in a car accident and you sue someone for damage to your vehicle, but your insurance company has paid to have your vehicle repaired, in your insurance documents, there's probably a document in there that says, or there's probably a clause in there that says that they have a right to reimbursement. They have a right to recover the money that they spent out of your recovery. So they're just like an insurer. They don't join these causes of action. Someone said that they did, and they cited some lawsuit that wasn't PI related, and you just don't know what you're talking about. And then they doubled down on stupid. But anyway, he said that Iran was that there was a high probability of internal strife because Iran is only 60% or so, I forget the exact number, Persian. There's a lot of other ethnicities there, like the Kurds and things like that. And I thought that was very interesting, because what he's tacitly doing is he's tacitly admitting that diversity is not our strength, that we shouldn't be diversifying America as strongly as we are. It's not good for the citizens. It's not good for stability. It's not good for political unity. I mean, obviously, we haven't had political unity in a long time, if ever. But it is a tacit admission that diversity is not our strength. And the U.S. is significantly more fractured than Iran as far as diversity is concerned. And I'm not advocating for a homogenous society anymore. I think that ship has long sailed. You know, I have mixed race children. I'm married to a non-white woman. And, you know, I'm not advocating for that. But what I would advocate for is cultural homogeneity. You know, China works because everybody in China considers themselves to be Chinese. There's a lot of different Chinese ethnicities. You know, I don't know them all, but you've got half the country speaking Cantonese, half the country speaking Mandarin, and the other half of the country speaks something else. I mean, there are a wide variety of languages. There are a wide variety of sub-ethnicities, I guess you would call them, in China, but they maintain because everybody is Chinese. Everybody is Chinese first. And I say everybody, of course, every country has dissident groups, but you get what I'm saying. And I'm not trying to say China is better than the U.S. I'm just pointing out this underlying fact. And if we could get to an understanding of the U.S., that the U.S. has to come first, that instead of being a hyphenated American, Cuban American, German American, whatever American, that if everybody was an American first and foremost, and we had a culture that instead of celebrating diversity, instead of elevating all of the subgroups over the norm, the majority, if instead we had everybody assimilate, like what America was supposed to be, a melting pot where everybody kind of assimilated, and instead of maintaining your ethnic and cultural kind of identity, you just became an American, I think we would have a much, much stronger country. I'm going to be accused by Barry of being a white supremacist, and he's adorable. I find the guy hilarious. Anyway, I've rambled long enough. Those are your thoughts for today. Thanks for watching. Have a great day.